Yep.
The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. I'm Amy Quackenboss, the Deputy Executive Director of the American Bankruptcy Institute. For those of you who are not familiar with us, the ABI is the largest multidisciplinary, nonpartisan organization dedicated to research and education on matters related to insolvency. As an ABI member, you have access to a wealth of free online research and networking tools, as well as quality CLE programming. And today I'm pleased to welcome you to the latest in our webinar series, ABI-Live. Our webinar today will cover everything you need to know about the foreclosure process. In 2010, there were almost 3 million foreclosure filings nationwide. This webinar will provide experienced and novice practitioners alike with the tools needed to advise on these situations. Today's panel will address current trends in foreclosure actions, including U.C.C issues, impediments to lenders foreclosing, and alternatives to foreclosure, and a comparison between foreclosure and bankruptcy. Today's webinar is hosted by ABI's Real Estate Committee. There are a couple of housekeeping matters to discuss before we introduce the panel. First, if you purchase CLE for this program, please make sure you just jot down the CLE codes that will appear throughout the program. You'll receive a follow-up email from us with directions on how to get your CLE credit. Also, if you have any questions that you would like to ask the panel during the program, you can just type the questions at any time in the questions box that appears in the webinar control panel to the right of your screen. These questions will go straight to our panel and will be addressed as time permits at the end of the program. I now have the privilege of introducing the moderator for today's panel. James Brand is a shareholder in the Minneapolis office of Frederickson and Byron. James guides businesses through the Chapter 11 process. He has represented trustees and receivers in preference and fraudulent transfer litigation and has defended similar actions across the nation. James is also a Rule 114 qualified neutral on the Minnesota statewide roster in civil law and has served as an adjunct professor of law at William Mitchell College of Law and an adjunct associate professor of law at the University of Minnesota Law School. James, welcome and thank you for moderating today. I'll let you introduce the rest of the panel.
Thanks, Amy, and thanks everyone for joining us for this interesting and timely panel on the topic of foreclosure. As Amy mentioned, my name is James Brand, and I'll be moderating today's panel. Given the number of foreclosures that happen each year nationwide, most insolvency practitioners are asked on a regular basis to advise on foreclosure issues. And even though foreclosures are down as compared to last year, the numbers are still staggering, so the topic is an important one. Before I introduce the panelists, I'd like to give some thanks to Brian Kaplan and Martha Cannon for organizing the panel and bringing it to fruition. And now to the panel. We have a great panel of experts here. Joining me are David Gold and Mark Gittleman. David Gold is counsel with Perkins Coie in Chicago in the firm's corporate practice. He concentrates on financial restructuring, bankruptcy, general commercial litigation, and distressed workout. His practice involves all manner of representing debtors, creditors, trustees, both in bankruptcy proceedings and just in out-of-court restructurings. Mark Gittleman is the managing chief counsel for bankruptcy and business reorganization for PNC Bank, based in Philadelphia. He's primarily responsible for providing legal services for PNC Bank's troubled loan portfolio. Prior to joining PNC Bank in 1992, Mr. Gittleman practiced at Blank Rome in Philadelphia, and he's a frequent lecturer on bankruptcy and U.C.C issues. We're extraordinarily lucky to have these two highly accomplished panelists, and I'll do my best to keep up. David will start the panel by providing an overview of foreclosure and U.C.C sale basics. Mark will then discuss proof of ownership of the debt and lender-specific issues in foreclosure from an in-house lender perspective. I will then finish up the panel by discussing several specific issues that may be in the relevant loan documents and how they would affect whether to file a bankruptcy petition in the face of a foreclosure proceeding. Please feel free to send in your questions at any time during the presentation. Depending on the question, we may hold them till the end, but there's no need to wait until the end to send your questions, as it may be useful to interject them throughout. So to kick off our panel, I'll turn the floor over to David to begin our presentation.
Hi, good morning. This is David Gold. Maybe good afternoon to those folks on the East Coast. I'll, as James mentioned, be giving an overview of foreclosure and U.C.C sales and a couple issues pertaining to them, I think, which will lead into the other presenters. Foreclosure. Obviously, I think everybody's kind of run across foreclosure. thus far in their practice. Maybe you participated as a party representative in one, or maybe it's just been the background of a case that you've walked into. But foreclosure generally is the process by which a secured lender is able to realize upon its real property collateral after a default. And in general, foreclosure can be both better or worse for a lender or borrower, depending on what their objectives are following a default, or when you're in that zone of insolvency. You, depending on the law, the state involved, could have more control over the process than a bankruptcy sale. And I'll get into that in a little bit. If it's consensual, it certainly can be quicker and cheaper. Even if non-consensual, it might be cheaper depending on the state. There's also less oversight. You don't have a Rule 2004, for instance, discovery that gets involved when a bankruptcy is filed, and there's certain other kind of trappings of bankruptcy that you just don't have to deal with when you have a foreclosure from either the borrower or the lender side. And in general, there's somewhat of a difference between a foreclosure sale and a bankruptcy sale. A bankruptcy sale can be free and clear of all liens and interest if properly done, whereas generally a foreclosure sale only is free and clear of junior liens and interests. This includes leases as well. So if there's a senior lender foreclosing or a senior lender that is thinking about foreclosing, that generally wipes away all liens and interests because everything is junior to it, but it's a consideration. And in general, title insurers will provide title commitments giving parties confidence as to what liens and interests that can be wiped out in a foreclosure. Lenders often obtain a title commitment, and it's something that borrowers sometimes consider getting to know the lay of the land of what's recorded on title. I think the one thing I should mention that's relevant to everybody's discussion, including mine, is that foreclosure is state-specific. I am located in Illinois. I've handled foreclosures across many states, and it's good to make sure, if you've never been involved in a foreclosure in a particular state, that you do a little research or potentially work with a local counsel to make sure that you understand all the ramifications of foreclosure in that state or any kind of local specifics. So there are two general types of foreclosure, and some states have one or the other. Some states have both, which then gives the lender the option of which one to pursue based on kind of what they're after. First, judicial foreclosure. The judicial foreclosure can last anywhere from a couple months, depending on the level of opposition a borrower displays, or even up to a couple years. And that includes everything soup to nuts, from a filing of a foreclosure action in a court to actually the sale and confirmation of the sale, either by the lender being the successful bidder or or another party. You can file in state or federal court. Federal court, you will need diversity jurisdiction to do so. But no matter what, state law will apply, regardless of whether you're in state or federal court. And in general, all a lender has to do in a foreclosure, sometimes it's more easily said than done, is prove its standing as the current lien holder, the existence of the debt, and a default. Generally, a non-payment of a debt or a default. Typically, you have a payment default. So as opposed to some litigation outside of a foreclosure, that a general commercial litigation or otherwise, that have a lot of different potential things that can happen along the timeline, including a potential trial. The key events in a foreclosure are generally the complaint being filed, if it's a commercial case, potentially a fight about an appointment of a receiver, a motion for summary judgment, because typically there's only so much in dispute in a foreclosure case in terms of potentially the debt owed, the status of the lender as lien holder, and potentially the existence of a debt, then a sale, and then confirmation of that sale. So some of the sale and confirmation concepts will be similar to what you see in a bankruptcy. And if it's a residential foreclosure as opposed to commercial, there's also typically a period post-sale before a homeowner actually has to leave their house, and this is sometimes a negotiated point between a borrower and a lender. So in general, for judicial foreclosure sales, you need court approval pursuant to a judgment. So the lender has to, either through summary judgment or trial, has to prove that it is there's been a default and that the lien holder and it has a right to foreclose, and the lender gets a judgment of foreclosure after that. The lender has to, so essentially the judgment in the case will include the right to foreclose and potentially the terms of that foreclosure. And there are minimal sale and notice requirements generally in every state, as opposed to what you see under 363. There's sometimes state mandated language to use in a foreclosure sale notice. Sometimes it's generally just the request of the party and what the court agrees to in a judgment. But the process is a lot, I wouldn't call it informal, but it's a lot less formal than you see in bankruptcy court, and it's a lot less. It's not so much subject to the dispute you have about sale noticing and getting court approval for that you see in a bankruptcy court. There are no stalking horse bidders, and somewhat similar to bankruptcy, but not exactly. But the sales are often dominated by secured creditors. There is no ability to limit credit bidding in a foreclosure sale generally, and you typically see, as opposed to a lot of bankruptcy sales, less participation from the general public or parties participating in those sales, and that may be because the noticing requirements in many states are simply just less than are required in bankruptcy court. For instance, some locales, a notice for a foreclosure sale simply has to be published in the local county paper, which, as you can suspect, for commercial properties may not actually reach the whole commercial market of what a property may be sold for. Residential foreclosures have a lot more spirited bidding and a lot more bidding from outside parties than commercial sales. And depending on the state or whether you file in federal court, the foreclosure can be handled by a sheriff, by a U.S. Marshal, or by a private sale. Though typically people don't usually use the U.S. Marshals and domesticate a foreclosure judgment to state court from federal court because the U.S. Marshals are very expensive. And similar to a bankruptcy case, once you have a judicial foreclosure sale, then you actually have to request by motion court approval of that sale, which is another opportunity for a fight if you're representing a borrower or a lender. It's another opportunity to kind of make sure the process is done right. Typically the fights you'll see are when there's a potential guarantor on the hook for any deficiency if the sale was not for the full value of the loan. And I guess over the last couple of years, we've had very little sales where there's a lot of equity in the property, and often there's a lot of deficiency left over that can often be an area where there's a fight. And in general, the confirmation standards can vary very widely by state. Some states allow nominal $1 sale bids by the lender. Some states require a lender to prove fair value, which may require appraisals or expert testimony, or at least an evidentiary hearing. So it's kind of important to know what your state requires in that respect, because you may still face a scenario where you're having a confirmation standard similar to a bankruptcy sale in that respect. For non-judicial foreclosures, it's a lot more simple in some respects. You're cutting out the court out of the process. The timeline is anywhere between a couple weeks and a couple months to complete the sale. It's initiated by sending a notice of a default to the borrower, and then there is also noticing of the sale, public noticing of the sale that's required. And the sale, depending on the state, the sale officer may be a public trustee, maybe a private officer. It really is state specific, and you often see very quick foreclosure sales unless there's opposition in non-judicial foreclosure states, let's say potentially in California or Texas. Because you can still seek a receiver in the states that have non-judicial foreclosure sales, but you see it a lot less because often receiverships, which require a court proceeding, can actually be slower than the non-judicial foreclosure process. So It's something lenders consider, and it's something from a borrower perspective that you may just not see as much in a non-judicial foreclosure state because the lender may think it can realize on its collateral faster than actually looking for a receiver. And despite the fact that it's non-judicial, a non-judicial foreclosure or power of sale foreclosure can still be delayed or challenged in court at every stage of the process. A party can file a complaint or motion for an injunction to enjoin a sale if they believe there's no default, or if the lender has done something improper or its loan documents aren't in order, and can also be challenged after the sale if the sale is not conducted properly. And as I'll discuss, redemption may still apply. And as I also mentioned, receiverships generally are involved in commercial foreclosures. They're sometimes seen in residential foreclosures, but you see it less because generally residential foreclosures don't involve income-producing properties by their very nature, and there's less of a concern from a lender perspective of making sure that nothing funky happens with the property, and making sure that the revenue stream is properly applied post default. You have less of a concern with that with residential foreclosures. You typically see a residential receivership where a property has either been abandoned or is in some sort of disrepair, where the lender has a concern about that. A receivership is where a party takes over the management and/or control of the property. It's almost always considered an officer of the court. The scope of the receivership really depends on the language of the loan documents and what state law allows. It can vary between anything. It can include all assets. It can just be a cash management scenario or a business management scenario. It really depends what the asset is. For instance, a hotel receivership would be actually generally running a hotel because that's how you protect a hotel as collateral, whereas an office park or an office receivership may just be more taking care of a property and or collecting rents. And a receiver steps into the shoes as a landlord and can terminate and execute leases. And it is important to note that under Section 543 of the Bankruptcy Code, that a receiver has to turn over property of the debtor's estate immediately following a Chapter 11 filing. So the longer a receiver has possession, the less likely a bankruptcy court will be to require the turnover if a party requests that the bankruptcy court excuse compliance with Section 543. So if you're in the shoes of a borrower's representative and a lender is requesting a receiver and you're thinking about a possible bankruptcy, you really have to make a strategic choice as to whether you want to allow the receiver order to potentially be entered, or even go to the hearing, or if you want to file, potentially put a company into bankruptcy before the hearing even happens, so that you avoid the fight about whether the receiver is going to turn the property back over, and you avoid a fight about whether the receiver has gotten established and is running the property well and should just be able to keep the property of the estate. And every state has some sort of redemption concept or reinstatement concept. It's generally considered paying the loan in full, but it could be just curing a default. It's very state specific, so you should make sure what the obligations are there. And it may be waivable in loan documents, but often is not from a public policy perspective. So many loan documents are not tailored to state specifics in terms of redemption and may have a waiver of the right of redemption, but that waiver may actually not be effective in the foreclosure. For instance, the state of Wisconsin, which I practice in regularly, does not generally honor redemption waivers inside of loan documents, even though loan documents will often have those waivers. Now, turning our attention to U.C.C. sales. U.C.C. sales are essentially the other side of the coin for personal property realization on collateral by a secured lender as opposed to on real property. And it's even less formal than what you see in a foreclosure, which is generally can be less formal than what you see in a bankruptcy sale. U.C.C. sales can be conducted prior to a foreclosure if there's also real estate pledged. It can be conducted at the same time as a foreclosure or afterwards. Typically, it's planned out by a lender who's got both personal and real property collateral if there's a foreclosure possible, to make sure that all the property is protected in whatever asset class it is. And so that's generally property specific. It's often initiated by the secured lender, but the secured lender actually does have to consent to have a sale under the U.C.C. And so why would you choose a U.C.C. sale over a bankruptcy sale? Very similar to why you might want to go the foreclosure route or allow a foreclosure if you're a borrower's counsel, that there's a lot less rigid controls such that you can actually tailor it to the specific property. You certainly don't even have any court oversight with a U.C.C. sale. And it's a lot quicker and cheaper than a bankruptcy sale. It's also a lot quicker and cheaper than a foreclosure sale for real property. And like a foreclosure sale generally, a U.C.C. sale is only free and clear of junior liens and interests. So you don't have exactly the power you have through Section 363. So that is a consideration if you're considering a U.C.C. sale from either the borrower or the lender perspective. I would note that it's always important, just like foreclosure sales, to read your state-specific statutes. Every state has enacted a version of the U.C.C. Some have slight differences to them. Usually they're not determinative, but you should still make sure that you're familiar with the U.C.C. that's going to be governing the potential U.C.C. sale that you're interested in handling. So basically, a U.C.C. sale has some trappings of foreclosure and bankruptcy sales, but a little different. A secured creditor or a borrower with the creditor's consent can sell personal property collateral upon a default without a foreclosure or any judicial process. One of the keys is that the borrower must be in default for that, for the U.C.C. sale to happen. The U.C.C. does not cover assignment of contracts or leases, so that is one weakness of it as a device as compared to what you can do through a bankruptcy sale. Although contracts and leases can be potentially assigned in a separate side agreement with parties who are bidding at a U.C.C. sale. And as compared to even a non-judicial foreclosure sale, they can be very quick. A U.C.C. sale can be done in as little as 10 days' notice to the debtor, to the borrower. And typically, a little more notice is given, but 10 days is all that's required by statute. So it can be done very quickly, and it's something to consider from a borrower's perspective when you have a default and you've got a secured creditor that has a lien on either all of your assets or at least your personal property, that secured creditor can very quickly notice up and schedule sale of your personal property, so you should be aware of your rights and what you can potentially do in response to a U.C.C. sale that's been noticed. And similarly to a foreclosure sale, there is no stalking horse bidder in the process. Theoretically, a secured lender could establish a stalking horse process, but it's not often done. And as I mentioned, a U.C.C. sale gives a lot of freedom to parties for noticing and bidding, which makes it potentially very quick and cheap, but it can invite challenges because there's less of a structure to it, or can be less of a structure, and you don't have a court approving ahead of time the terms of the sale, the terms of the noticing. So it allows that freedom to be able to craft it to be very specific to the asset class that's involved, but it also invites challenges based on that freedom that the secured creditor can have in noticing that sale. And just like a foreclosure or just like a non-judicial foreclosure, a U.C.C. sale can be enjoined or later challenged in court if done improperly. So although you have a lot of freedom, you should still make sure that you're following the requirements of the U.C.C. and also good practices. And an important little quirk is that U.C.C. transfers title but not possession. So there are scenarios in which a party that has possession of the property, a borrower, may not tender or be willing to tender possession of property that's sold by a U.C.C. sale. And it gives potentially an option for a borrower to obstruct a sale either for legitimate or illegitimate purposes. So it's something that you have to be aware of when you're a lender, when you're scheduling one of these. And in general, the touchstone for all U.C.C. sales is commercial reasonableness under 9610B. Again, this gives a lot of freedom, but it also potentially can invite challenges. So what is commercially reasonable. Section 9627B gives a definition that says disposition of collateral, a UCC sale, is commercially reasonable if the disposition is made in a usual manner in a recognized market, if it's at a price current in the recognized market at the time of disposition, similar to fair value, or if it's in conformity with reasonable commercial practices. So all of that is to say, it's kind of whatever you kind of know it when you see it. It gives a lot of freedom for parties to decide what they think is commercially reasonable for a particular type of property and to go forward with that. But it also, again, can invite challenges. And there are certain general, practice guidelines for commercial reasonableness that people follow. For instance, typically a public sale versus a private, which I'll discuss, is can be seen as more commercially reasonable because you've given the market an opportunity to bid on the property. You can also, if you've got a concurrent foreclosure, seek a judicial finding of the commercial reasonableness of a sale that you've held. And if there is a concurrent foreclosure, it's often a best practice for a lender to seek the court's approval for the U.C.C. sale and also to seek confirmation of the U.C.C. sale in the court, although confirmation is not required in a U.C.C. sale, so that you have the comfort of a court order approving the commercial reasonableness of your sale. So one thing I mentioned was public and private. A U.C.C. sale can be public or private, but it does actually, the U.C.C. actually limits what can be subject to a private sale. And it says private sales can be for collateral that is of a kind that is customarily sold on a recognized market or the subject of widely distributed standard price quotations. And what that really means is some sort of fungible commodity type asset with standard market prices that may be exchanged on a national exchange. So a lot of properties sold in UCC sales don't qualify for that private sale. So most UCC sales generally end up being public. But if there is the right to hold a private sale, it may be useful to hold one. It certainly cuts down on the cost of noticing. You don't have to publish notice in a commercial marketed paper or a local paper. And regardless of whether it's a public or private sale, the secured party can credit bid at a UCC sale. The only caveat is that the private sale still has to qualify for the right type of asset to actually be a private sale. And finally, I just wanted to mention briefly UCC perfection issues. UCC perfection issues can be and should be resolved prior to a lender noticing a default. It's not always done, but in some scenarios, especially if you've got a concurrent foreclosure, that a UCC perfection issue can be, in some courts, fixed once a foreclosure is filed. Other courts won't allow that. It should be fixed before a UCC sale is actually noticed or sold or held, because it potentially undermines the sale itself. But unlike a bankruptcy, for instance, if you've got a concurrent foreclosure, the perfection issues and priorities are not always set as of the foreclosure filing date, as opposed to in a bankruptcy where if there is a petition filed, your rights to perfect your interests potentially aren't there post bankruptcy filing unless you're given a post petition security interest. So there's potentially a little bit more flexibility there for a lender to fix its issues if it has to file a quick foreclosure that aren't there if there's a bankruptcy filed. And also there's no, in a foreclosure or UCC scenario, there's no avoidance of newly perfected interest like there can be in a bankruptcy under 547. Under 547, if a UCC rights are perfected within the 90 days prior to the petition date, there is the potential that under 547, that perfection can be avoided under Section 547. So if you're a secured lender that is looking at holding a UCC sale or a foreclosure with a UCC sale combined, you should make sure certainly that your perfection interests are established, and if I'm representing a lender, for instance, I try to be very discreet if I'm trying to remedy or fix UCC issues, and there's a default, because there is a chance that my collateral and my rights as a secured lender over that personal property could be avoided if a bankruptcy is immediately filed. And similarly, if I represent borrower's counsel, if I represent a borrower and a borrower's counsel, I'm on the lookout for UCC issues and any attempts by a lender to try to remedy any issues. In terms of my considerations of whether I want to file the bankruptcy and when I want to file, because if you're able as a borrower's counsel to avoid a lender's security interest or perfection over personal property in the bankruptcy, it can give you quite a bit of leverage in negotiating various things in the bankruptcy, like cash collateral, or it can drive the whole course of the case if the lender doesn't have a perfected security interest. Thank you.
Well, that's great. Thanks so much, David. Let's turn now to Mark, who will provide a bank's insights into the process and some lender-specific issues.
Great. Thanks very much, and hello to everybody. As it says on my resume, I work for PNC Bank. So I'm going to talk about two issues that we see frequently as a lender, as a mortgagee. Some of these apply to big banks, some of these apply to every mortgagee. And the issues we're going to talk about also affect all the other parties involved in the foreclosure. So depending upon whether you are the mortgagor, or you're the guy who signed the mortgage, you're the mortgagee, the recipient of the mortgage, potentially a buyer of the mortgage, which we'll talk about in a minute, or some other party in the case, some other creditor, all these issues affect everybody in the case. So even though you may not be working for a bank, representing a bank, it'll be of interest to you. So think about large institutional lenders, highly regulated, even more so now than at any time in the past. Lots of regulations, and you'll hear some of that throughout this presentation. The first issue is the identity of the foreclosing creditor. So here's a term, the originator. The originator is the party that makes the loan. Could be a small mortgage company. You're buying your first house. You've got the ABC mortgage company that the realtor uses. You show up, they give you documents, you sign, you get your mortgage. The seller gets paid, and you're off and running the house paying this mortgage. Could be a big bank. Could be a big finance company or a credit union or a savings and loan. All these entities and many more put on mortgage loans, whether they're residential loans or they're commercial loans. We'll talk a little bit about both. It's pretty rare, though, that all those entities, all those originators, retain the loans that they actually put on. More likely than not, they sell them and get the proceeds back and have somebody else collect out. Who do they sell these loans to? Well, for consumer loans, sometimes they're sold to GSEs, government-sponsored entities like Fannie Mae or Freddie Mac as a part of their funding source. Fannie or Freddie provides funding for the loan, and then the loan gets taken over by Fannie or Freddie to collect or to sell as a part of some sort of security. Sometimes the loans on the consumer side are sold into securitization vehicles. For investment, you may hear words like a REMIC, a real estate mortgage investment trust, or a CMO, a collateralized mortgage obligation, or an RMBS, a residential mortgage-backed security. These are all big investments that include a large pool of these loans that throw off cash as the borrowers pay, and you get your investment back by the interest that's paid on the loans and when the loan finally pays off. Now, sometimes the loans are sold or administered by a group called the Mortgage Electronic Registration System, or MERS, and MERS serves as a servicer to actually collect payments, and if there's a default, to actually undertake collection action, including foreclosure. So right out of the gate, sometimes even the day after your loan closes, it gets sold off to a third party. Now, commercial loans also get sold by banks. Now, many banks hold on to large commercial loans for their own account. That's the way they make money. They make a loan, and the interest you pay is some of the revenue a bank will retain. But sometimes banks sell commercial loans into securitization vehicles, like a REIT, a real estate investment trust, or a CDO, a collateralized debt obligation. Sometimes they're also sold into securitization vehicles or portfolios, which are administered by servicers and sometimes special servicers under the servicing agreement. So in a securitization, a large pool of commercial loans are sold into a special vehicle, sometimes called an SPV, a special purpose vehicle. There's a trustee appointed for the purpose of collecting the loans, and the trustee is now, in essence, the mortgagee, the trustee for this special purpose vehicle. And the trustee goes out and hires a servicer under a servicing agreement to actually do the nuts and bolts work of actually collecting the money, putting the money against the loan, categorizing the payment, and if there's a default or a collection action, the servicer may bring in a special servicer to actually do the collection or foreclosure work. A lot of different parties there. Now, sometimes lenders also sell off specific commercial loans for reserve reasons or financial statement reasons. They have a loan that may be distressed, they want to get it off their books, or a loan that they want to sell and someone's willing to pay a price above 100% or above par for the interest gain, so they sell it off on a one-off basis. So loans can be sold off in one-offs, or they can be sold as part of portfolios. So what happens to the mortgage that's filed of record once these loans are sold off? Some states, Pennsylvania for example, does not require an assignment of mortgage to be filed of record for the assignment to be effective. Other states, Wyoming is another example, actually require the assignment to be filed of record for the assignment to be effective. But what do mortgage servicers do? Here I'm a mortgage servicer. I've just been asked to service this large portfolio of 1,000 loans, whether it's commercial, consumer. Do I want to file a mortgage assignment for every one of those loans? So if I'm a trustee, I could have it assigned to me, but now I have to file 1,000 assignments. And if I hire a servicer, do I have to have another assignment to show that the servicer has the rights to collect the loans? And if I bring in a special servicer, do I need to have another assignment to show the special servicer? Many mortgage servicers actually often choose not to file the assignments to save on that cost and administrative expense. Or in the consumer world, servicers may actually just assign the mortgage to MERS, and MERS handles all the activity of collection and potentially foreclosure. But what if there's no mortgage filed of record? Who's responsible for filing that? Presumably in a sale, the buyer is responsible for filing the assignment. The assignment benefits the buyer that shows the loan is now in the buyer's name. So the buyer should file the assignment, but they don't always do that. And also if there's an assignment for a servicer or a special servicer, do you need to have the special servicer's name on to do the foreclosure? Not all servicers do that either. Many times they'll use MERS or they'll use a special vehicle that they'll use for the foreclosure purpose, but not every servicer is that sophisticated. And there are legal issues as well. Who keeps the record keeping? Where is the record of all the payments made on the loan held? Is it held by the originating bank? Is it held by the SPV vehicle that ends up with the assignment of the mortgage, held by the trustee? Is it held by the servicer or the special servicer? And it can change through the life of the loan, especially if the loan goes bad and is transferred from a servicer to a special servicer just prior to foreclosure. Sometimes servicers will file something called a master assignment. If it's a very large portfolio of tons and tons of loans, instead of filing specific assignments, they'll file one master assignment in as many jurisdictions as there are mortgages, with a large list of assigned mortgages attached to the assignment. So trying to do a search to determine who your owner is of the mortgage may be very difficult if all you're left with is one giant master assignment. And most importantly, who is the history of the loan? So if somebody's trying now to do a foreclosure, now we're to the topic of foreclosure, who has the prior history? Has the borrower put up a stink? Was there a problem with collecting the mortgage or collecting payments? Was interest correctly charged? If it was a floating rate, was the interest correctly changed when the rate changed? Who monitors all that? And can somebody actually be the full history of the loan? So now you're ready to file the foreclosure action. What do you have to show? And we talked about this in the prior section, but I'm just going to reiterate a little bit. In your foreclosure complaint, most states require you to aver the following: the parties to the mortgage, the mortgager, and the mortgagee, and any assignee, a description of the land covered by the mortgage, the names, addresses, and interest of the defendants. So it may not just be, as a defendant, the owner of the property. If there is a tenant who has a lease file of record, you name the tenant. If there are subsequent mortgagees in the foreclosure, you name the subsequent mortgagees, so that when you complete the foreclosure, the effect is to wipe out subsequent mortgagees. Going back to the prior presentation, that's why filing and priority is important, not just on the real estate side, but also on the U.C.C. side. When you complete a foreclosure sale, you must give notice to all other creditors filed of record, whether ahead of you or behind you, especially behind you because it wipes them off the record when you own the property. If you fail to give notice to the proper party and you complete the foreclosure sale, you've not eliminated that subsequent lien. You have to do another foreclosure or have to pay off that creditor to get them off the record. So you also have to aver the default, an itemized statement of the amount due, and a demand for judgment of the amount due. What happens now that you're starting a foreclosure and you're with MERS or you're representing MERS, some special servicer, and you're a lawyer and you want to file the foreclosure complaint, and you call up your client and say, okay, I need all this information for the complaint. The parties I have the mortgage, it's file of record. The land is attached to the mortgage as the legal description. I think I know who all the parties are. I've run a search to see who the defendants need to be. I can avert the default and the statement of the amount due. But now I also have to attach to the complaint a copy of the note that the mortgage secures. And with every mortgage, as we all know, the mortgage is the tail that wags the dog. The note is the debt instrument. The mortgage is merely the lien instrument. But if you're doing a foreclosure, you're foreclosing the lien instrument. You need to aver the debt instrument. So now you need a copy of the note. And now the lender can't find it. And if you think about the chain of title where that poor note started in some small mortgage company in your hometown that went to a GSE, or it went into some sort of commercialized vehicle, or it went into some sort of securitization, or it went to a servicer and then a special servicer, who knows where the note is? Similarly, even if the big bank held onto the note and it started as some small bank in your hometown that was merged into some bigger bank, merged into another bank, and then merged into some very large bank, what about the records if you can't find the note? Can you file the foreclosure action without the original note? In almost every state, the answer is yes, but not every state. Some states do require the original note. Florida, for example, is a real stickler for showing up with the original note. Sometimes you can just show up with a copy of the note, and a copy should be enough to get you through the original state of filing your complaint. What if you don't even have a copy of the note? Can you file the foreclosure action? Or even worse, if you have a copy of the note, and the note shows by allonge or assignment of the note that the note is now owned by MERS or the special servicer or the trustee of the investment vehicle, but the mortgage is still in the name of the original originating lender. How can you show that the foreclosing creditor, the party, the mortgagee foreclosing, is appropriate to foreclose without an assignment file of record? That can be a real problem. So you have to go back and get the original mortgagee, the assignor, to sign a new assignment. They're not always there anymore. Banks disappear, mortgage companies disappear. They may refuse to sign for whatever reason. So how do you file your complaint? Banks and mortgage companies and MERS and servicers do that all the time. And sometimes the borrower doesn't object because they know they owe the money. Sometimes they do. So we've included 3 cases that are really just representative cases, but this is a trend you're finding all across the country where judges at an appellate level are kicking out foreclosure actions or dismissing foreclosure actions because the name of the mortgage or the mortgagee doesn't match the name of the owner of the note, specifically because of this record-keeping reason. The Ohio case was particularly egregious, and there's a sister case. In this case, listed here, there were 14 foreclosure actions knocked out. There was a sister case at about the same time which knocked out a large number of other foreclosure actions, merely because the foreclosing creditor on the note did not match the name of the mortgagee on the mortgage. In the Florida case, it was actually even a harder set of facts. There was a summary judgment entered in favor of the original creditor for foreclosure. It went up to the appellate court. The appellate court reversed the summary judgment because the original complaint had insufficient evidence that the foreclosing creditor owned the note. The note was endorsed. The originator gave an affidavit. And in fact, there was an assignment filed on the record. Unfortunately for this creditor, the assignment was filed after the complaint was filed. So on the date the complaint was filed, when they're referring to the court who owns the properties, or who owns the mortgage, the foreclosing creditor was not shown on the record as owning the mortgage. So their foreclosure complaint was actually kicked out. They had to start all over again. In the third case in North Carolina, also a similar set of facts. The trial court's granting of the foreclosure judgment was reversed by an appellate court because the foreclosing creditor did not provide evidence of the assignment from the originating lender to the current holder. So it's sort of taking defeat out of the jaws of victory. The rule of thumb for me is one time is an aberration, two is a coincidence, three is a trend. Clearly a trend among courts throughout the country that if you, as a foreclosing creditor, can't show that you're the owner of the note and the owner of the mortgage of record, you may not be able to complete your foreclosure action. So it's important right out of the gate, representing a lender to start a foreclosure, that you line up all of your documents, your note, your mortgage, your allonges or assignments of the note, and the assignments of record of the mortgage, so that you can show the ownership and the interests of the foreclosing creditor. Similarly, and at a bank, this is sort of unique to banks, banks that are the survivor of a number of mergers, as PNC is. Sometimes the original mortgage is in the name of a predecessor bank. Sometimes it might be 2 or 3 predecessors ago if the mortgage went on 7, 8, 10 years ago or even longer. So to start a foreclosure action now, not only do we aver that we're the owner of the mortgage, but we have to show all of the merger certificates going back to the little bank in your hometown that was bought by a bigger bank, and then ultimately by PNC, to show that we're the owner of the mortgage by virtue of merger. Most courts will accept that, and you have to have as a lawyer, you have to be prepared to show that right up front. So that's sort of the biggest issue we're seeing now in foreclosure cases. I want to spend the rest of my time just talking quickly about what happens post-foreclosure for something called OREO properties or other real estate owned. All right, so let's assume that you actually completed your foreclosure action as the creditor and you bought the property in a foreclosure sale. You gave appropriate notices. Any other creditor has been noticed, so they're wiped out by the sale. You've bid in your property, and you were the successful bidder at the sale, and assuming it's a sheriff's sale, you received the sheriff's deed or the state deed made out to you or your OREO subsidiary, and now you own the property. Usually before that, as a foreclosing creditor, you want to take a certain number of steps to know what it is that you're actually buying at foreclosure sale. Many banks are required to do this by regulation or policy anyway, but it's an important list, so even if your bank doesn't do this or your client as a foreclosing creditor doesn't do this, it's a good set of steps to take. Doing a current appraisal of the property, making sure that what you're foreclosing on is in fact worth the amount of money that you're going to spend to go through the foreclosure, go through the holding and marketing of the property, and then selling it. You'd be amazing what people put mortgages on that have very little value. Doing a title search to make sure prior to foreclosure that you're actually foreclosing on the right property. Sometimes legal descriptions get mixed up at a closing. The wrong legal description gets attached. Sometimes not every tract or parcel involved in the property is included. Making sure that the parcels you foreclose on actually have access, ingress, and egress so that you can actually get to your parcel and sell it so it's saleable. Or if not, that there's some sort of easement across other properties to be able to get to it, conducting an environmental report to make sure that there's no gaping environmental issue on the property, oil isn't spewing up from some sort of hole in the property or something like that, conducting a site visit to make sure the property is where it's supposed to be. We did a foreclosure a number of years ago on a development in Maryland, and we went out to do a site visit. And you know how sometimes you'll hear that a property's underwater by value? Well, the properties we were foreclosing on were actually underwater. There was some sort of flood, and they were on the Chesapeake Bay, and they were actually in the Chesapeake Bay, so it made the foreclosure very difficult. And finally, make sure that you have all the internal approvals you need to be able to conduct a foreclosure. Again, some regulatory agencies require some sort of internal review process before you conduct a foreclosure. Make sure that occurs and ask that of your bank client before you start the action. All right, so now you've taken in the property. The property is called OREO, which stands for Other Real Estate Owned. It's defined in the federal regs listed in the materials. So here are some considerations when you want to take OREO property onto your books and records. Most banks and other secured creditors take OREO property not in the name of the institution itself, but they'll form some sort of subsidiary. You hear me use the phrase OREO sub, a subsidiary solely for the purpose of holding foreclosed real property. And you'll see why in a minute to try and counteract some of the risks. The pros of conducting a foreclosure and taking the property in, pretty simple. Once you've taken the property in, now you can control the time, manner, and price of sale without interruption from the original mortgagor or other creditors. You've wiped out the ownership interest of the mortgagor by the foreclosure sale. You own the property now. And you've wiped out all the other subordinated creditors or subordinate creditors. So if anyone files bankruptcy, doesn't stop the sale. If other creditors attempt to start a foreclosure action, it's too late. Their lien's wiped away. So now you can control the sale price and the terms and the time. You can go hire your own broker, or you could sell the property yourself by auction or some other method. Where prices are appreciating in value, you can choose to hold the property yourself to gain from the increase in value. So if you end up foreclosing on a property in a hot area, a resort town, or maybe a hot corner in your hometown, where you know the price of that property is going to appreciate, you may decide you're going to hold that property on your books for a period of time. Not too long, as we'll hear in a minute, but you have the ability to gain by appreciation if possible. I have to say, in most circumstances, you rarely see that when you're foreclosing on a property. The reason you're foreclosing is because the borrower hasn't paid, and the borrower hasn't paid because the property doesn't have the value they thought it did. If the property had the value, more likely the borrower will file bankruptcy to stop the foreclosure, or will be able to refinance or sell the property to be able to pay off the foreclosing creditor before it gets through the foreclosure process. So it's pretty rare you're going to find a property appreciating in value, but it does happen. Finally, you can gain income from the tenants on the site while you're awaiting disposition. So if there are tenants on the site, it's an income-producing property. As the owner, you get all that income off the property while you're waiting to sell it to a third party. Now, there are cons as well, and the negatives for owning property start with what started as the original pro. So you're gaining property, you're gaining monies off tenants on the site. You're now the landlord. So if a light bulb goes out, or the elevator stops working, or the toilets don't work, you as a landlord are now responsible to fix it. And you're just a bank, or you're a secured creditor. How do you fix it? And it means sometimes you have to hire a management company at your cost to go out and act as the landlord to fix the property. And that costs money. All the other liabilities of ownership are also now your responsibility as owner of the property. So insurance issues, maintenance issues, management issues, something breaks, taxes, you have to pay the taxes on the property, zoning issues, condemnation issues, blight issues, issues of tenants on the property, all the things that you would find in the property as an owner now become your headache. So you have to judge whether or not there's value to you to be able to hold the property as OREO, or not foreclose on it at all. There's reputational risk also for high-profile properties. As a quick story, we had a lien on a property in Detroit, and we ended up foreclosing on it and owning it, and it was falling down. And in fact, the Thanksgiving Day parade in Detroit was running right by the property, and there was a concern that the facade of the building might actually fall on the parade. So they came to us to get us to fix it or bolster it up, which we were happy to do. But again, the last thing you want to have is your name attached to a property that's falling down on top of the Thanksgiving parade in a major city. So again, high-profile properties could lead to reputational risk. Can the OREO sub-seller deliver good title? You would think that if you're getting a deed out from the sheriff or a deed out from the foreclosure sale, that you'll now have good title. That isn't always true. Now, as a practice at PNC, we always get a title insurer to insure the title coming in from the sheriff or from the seller at the foreclosure sale so that we can flip it and have that good title to be able to sell to third parties. Not every lender does that, but it is a good practice to be able to sell with good title, know that you're taking it in with good title. And finally, as we'll talk about in a second, there are a ton of regulatory issues in taking in OREO properties, especially for large regulated entities like banks. So let me take a minute and talk about those. Before we get there, I see that there's a question up. When an alleged servicer violates Title 15 by claiming to become servicer by virtue of recorded assignment rather than by agency agreement, does that trigger California State's mortgage fraud statute against recording fraud and misrepresentations in the land records? Now, I don't practice in California, so I'm not sure I can answer that question. But there have been issues where there have been fraudulent filings, not just in the real estate records, but I've also seen it in U.C.C. records, which could lead to some sort of fraud claim by the filing authority. More likely than not, fraud is less of an issue than just losing your ability to do the foreclosure. But it clearly is an issue if you're going to attempt to foreclose on something that you don't own or that there is some sort of fraudulent filing. You really need to take care of the fraudulent filing before you move forward with the foreclosure. Another question. If the lender credit bids and wins, transfers to an OREO sub, does the lender's brief holding of title create exposure to lenders of OREO sub foreclosed to avoid that? In many states, when we do that, we will actually assign the note to the OREO sub prior to the foreclosure so that the OREO sub is actually the foreclosed entity. So the property never goes actually through the lender to avoid that brief holding of title issue. Not every state allows you to do that, and sometimes there is some sort of recording tax when you have to show that assignment. So you have to check with your local lawyer to see what the practice is in that state. All right, so let's talk about the regulatory issues and to finish up my time here. As I mentioned, how long can you hold a property? Federal regs require that you can only hold an OREO property for 5 years. Now, you can get an extension. It's harder now to get an extension than it used to be. But the 5 years is a pretty tough time period, especially if it's a hard-to-sell property. And we've actually had properties in our OREO unit that have been impossible to sell over 5 years. So at the end of the hold period, you must dispose of the property at any price. So in selling it to Grandma for $1, to get rid of the property, we'll sell it to Grandma for $1 because we're required to get rid of the property, or the regulators will be very unhappy with us. When you take OREO property, you need to put reserves on your books to appropriately value the property on your books and records. And if the property is not worth what you thought it was worth on the day you foreclosed, that's an additional loss you have to take on your books and records. And then you need to revalue the property periodically by way of appraisal. So the property again declines in value. You may have to take further losses on your books and records as an asset you own, this piece of real estate, continues to decline in value. So you have to value it appropriately when it comes on your books and records, and you need to be somewhat careful about the valuation to make sure the valuation is fair and not just benefits you, but also anticipates reductions in value. There are a lot of other issues. I just listed a couple here. And this is the big one that we've been dealing with recently, the Bank Secrecy Act, Patriot Act compliance. When you're dealing with crooks, terrorists, money launderers, recent gambit they've been using is buying OREO properties for cash. That's how they launder dirty money through into this country. They bring the money in, they buy an OREO property from an eager bank looking to dump a property. They pay cash for it without any financing, and then 6 months later, or even less, they'll sell the property for the same price, or maybe a slightly larger price. And now the money they've gotten back from the real estate sale, clean money because they've washed it through this piece of real estate. So banks need to be much more vigilant when they are selling OREO property as to who they're selling it to. Is this person a known criminal? Is it tied to a terrorist organization? And banks are now doing checks with the Office of Foreign Asset Control, or OFAC, and doing other checks to make sure that the buyer, whether it's an individual or a company, and you have to check the individuals who own the company as well to make sure they're not tied to criminal or terrorist acts. It's a huge issue now for holders of OREO property. Second is a registration of vacant properties. Many jurisdictions across the country now require registration of vacant properties. And if the holder, the owner of that property, fails to register the vacant property, there are fines attached, and the fines are levied daily. So if you own an OREO property and you fail to register it, and the fine is $20 a day, after 30 days, the fine starts popping up, and if you fail after 6 months or a year, the fine could be fairly hefty. There are companies that you can contract with that actually do monitor these registration statutes. So if you have an OREO portfolio, you can actually have them help you manage registration for your vacant properties. But it's a really important issue. Cash for key statutes, another local law issue that you're seeing more and more of a trend. If you have a tenant on the property and you want to get rid of them, it's not, especially if it's a residential property, it's not as easy now to file a quick detachment action to them off the property. There are some jurisdictions, Chicago, for example, where if you want to get a tenant off the property, you have to offer them cash, and the cash is set forth in a formula in the local ordinance or statute in order to get the keys from them. So be wary of these cash for key statutes. There may be more money out of pocket for you to actually own and take a vacant property or to get the tenant out of the property than may be worth. And then the last are just local nuisance ordinances. Jurisdictions require the grass to be to make sure that the property is safe so that people aren't squatting in there or kids aren't playing in there as a nuisance. And you have to upkeep the property and make sure that it's kept safe and not held out as blight in a particular neighborhood. Localities don't like having blighted properties in their areas. And if you're a bank, they'll make sure to take it out of your hide if you have a property that requires some sort of upkeep or some sort of condemnation and demolition if the property is not in great shape. That's the presentation.
Thanks very much, Mark. What a fascinating peek into issues faced by lenders. Let's now turn to considerations from the debtor side when considering how to respond to a potential foreclosure situation. I'll address three situations that, based on a review of generally commercial loan documents and organizational documents of the debtor, may push the needle towards or away from filing a bankruptcy petition. This, of course, assumes you have viable prospects for a plan or a sale and entirely glosses over other aspects of determining whether to file a bankruptcy petition. But I want to focus in and highlight three provisions in loan documents and describe how they may provide reason, number one, that you may not want to file, number two, where you may want to file, or three, that you actually cannot file. So turning to that first issue is the reason that you may not want to file. And this is the issue of springing recourse. These provisions are sometimes called bad boy guarantees, and they convert a non-recourse loan to a partial or fully recourse loan upon the occurrence of certain things. Although the triggers vary quite widely, common examples are fraud, misapplication of funds by the borrower, transfers of the mortgaged property, or the filing of a bankruptcy petition. In other words, filing of a bankruptcy can trigger full recourse and so can create more problems than it may otherwise solve. So just to play it through, upon a borrower's filing, the guarantee liability is triggered for a third party. Oftentimes, those guarantors are decision makers and have the ability to control the filing. That's actually why they were required to sign this type of guarantee in the first place. Obviously, this raises issues of such guarantors' fiduciary obligations to the debtor. If a bankruptcy filing will have significant individual implications for that person, what considerations ought they to be thinking through in determining whether to file or cause the entity to file? Without going down that rabbit hole, it's safe to assume that the presence of this guarantee will influence the debtor's behavior. Now, debtors often ask if the automatic stay can be extended to protect third parties. Courts will extend the stay in limited circumstances, primarily based on the effect the third-party litigation will have on the debtor, but I have not found any cases that have extended the stay under these circumstances of a springing guarantee. If anyone on the line is aware of one, I'm interested to read it, so just fire up your chat feature and send it my way. The takeaway here is that for a bankruptcy filing, it may trigger additional liability, and the automatic stay is likely not available to shield that third party while the bankruptcy is pending. You can move to the next slide. This is not just a bankruptcy issue. Certain actions under a state law proceeding may also trigger springing recourse. These would include actions such as even opposing a foreclosure or asserting counterclaims. I should also note that several states have enacted statutes that affect springing recourse provisions. For example, 5 years ago, Michigan passed a law which provides, quote, a post-closing solvency covenant shall not be used directly or indirectly as a non-recourse carve-out or as the basis for any claim or action against a borrower or any guarantor or other surety on a non-recourse basis. So this does not knock out springing guarantees altogether in Michigan. It just overrides one particular trigger, which was a post-closing solvency covenant. So to recap, this isn't a pure, the presence of a springing guarantee isn't a pure whether to file bankruptcy or not issue. In reality, it's how ought we to respond to a distressed situation. The takeaway is that springing recourse provisions will influence the approach in negotiations in any distressed circumstance. Turning next to prepayment fees, I want to shift to this issue which may be a reason to file a bankruptcy petition. Now, this is not a new issue of prepayment fees. Courts have struggled with it and dealt with it for a number of years now, but it continues to be an important one and provides a fascinating narrative of the development of the law and how commercial parties have responded. Over the years, bankruptcy courts have disallowed prepayment fees or prepayment penalties on a number of theories, including that the fee was not properly triggered under the loan documents, that the fee is actually an unenforceable penalty, or that the fee is actually unmatured interest, which is not allowable under the bankruptcy code. And in general, bankruptcy courts have proved to be more debtor-friendly on this point, largely because the bankruptcy code provides additional tools and layers of analysis beyond simply whether the fee is enforceable as a matter of contract law under the state law. Next slide, please. As mentioned, some courts have disallowed prepayment fees on the basis that they were not properly triggered under the loan documents. Now, this is a really interesting issue because it's evolved over time and in response to the language of the loan documents. Some earlier cases had found that a prepayment provision was not enforceable if the loan had already been accelerated, on the theory that there was no longer a voluntary prepayment that was possible. Banks responded and drafted provisions that would be effective upon acceleration, whether voluntarily or not. And faced with that situation, some courts have still found that if the loan was not accelerated pre-petition and bankruptcy is filed, then the only way it would be allowable post-petition would be as a reasonable fee, cost, or charge under Section 506B, which we'll talk about in a moment. The lesson here is that a careful reading of the prepayment provision may reveal a strategy where bankruptcy could provide a more favorable outcome for the debtor in comparison to a foreclosure proceeding. Either if older loan documents are in play or the right factual situation presents itself, that may be the time where this pushes the needle towards the bankruptcy filing. Next slide, please. A number of courts, both bankruptcy courts and state courts, have analyzed prepayment fees in the context of unenforceable penalties and have expressly used a liquidated damages analysis. For bankruptcy courts, there is a state law component to this, as lenders a lender's claim must be enforceable under non-bankruptcy law. The 400 Walnut Associates case on the screen provides an example of this. However, Section 506 of the Bankruptcy Code provides an additional overlay. It provides that a secured lender's claim may include reasonable fees, costs, or charges. And the often cited Duralite Truck Body and Container Corp case provides this. A prepayment charge formula must effectively estimate actual damages. Otherwise, the charges may operate as either a penalty on the debtor or a windfall to the lender at the expense of the other creditors of the bankruptcy estate. Only a prepayment charge formula that reasonably measures actual damages will be respected under Section 506. This additional overlay means that bankruptcy courts may provide a more favorable forum for debtors on this issue. Next slide, please. The last theory that I'll discuss links directly to this liquidated damages analysis that some courts use. Prepayment penalties are sometimes structured as yield maintenance provisions and are calculated based on a spread to treasuries or some other formula. The point being that they're to estimate the lender's loss, assuming the lender puts the prepaid principal into these treasuries as compared to continuing to receive the contracted for payment. And it's that difference between those two that would constitute the yield maintenance fee. This would seem to be an answer to the liquidated damages analysis, as it effectively and quite precisely estimates the actual damages with the assumptions of where the money would go. However, some courts have denied allowance of such fees on the basis that the fee is actually unmatured interest. For example, it's interest that will come due in the future, which is expressly disallowed under Section 502b2.
Okay, I will talk.
Now, this theory has not gained much traction, but it is an argument that's available only in bankruptcy.
Okay, gotcha.
Therefore, in sum,
Is that
if
for the live
the
stream, or
loan
is it
documents
for the
have a
virtual
substantial
phone?
prepayment fee, a bankruptcy forum may provide a more favorable outcome to litigate or negotiate that
Oh,
issue.
okay, gotcha.
It's just our phones. Right?
Okay, gotcha.
Next slide.
I have your recording.
Finally, I'd like to talk about an issue in the debtor's organizational documents that may mean that a debtor is not able to file, or at least it will require some litigation to get to that point.
We were curious to see.
In order to file a petition, the debtor must have the corporate authority to do so, obviously, and must provide evidence of that authority right at the
Was there
get-go.
an email mess up? Or with the
One
virtual
tool that
one?
some lenders use to protect bankruptcy remote entities is a blocking director, which is a corporate structure that places an independent director on the debtor's board or other organizational body and requires that the director consent to authorize any bankruptcy filing. The obvious purpose of that director is to withhold such consent and thereby blocking the filing of a bankruptcy petition. A recent case out of Chicago demonstrates how this works and how bankruptcy courts may respond. I'll skip through a recitation of the facts in the opinion and simply refer you to the site that will appear back after the CLE number comes off your screen, given the constraints of time at the moment, and jump right to the holding, which is that in analyzing the situation under Michigan corporate law, the bankruptcy court determined that the blocking director structure in that case was improper because a member of the LLC cannot entirely disclaim its fiduciary duties to the entity. There, the member, the newly appointed member for that blocking position, was specifically disclaiming any other duties. The court described the issue as this. The essential playbook for a successful blocking director structure is this. The director must be subject to normal director fiduciary duties, and therefore in some circumstances vote in favor of a bankruptcy filing, even if that is not in the best interest of the creditor that the director was chosen by. The takeaway here is that the debtor, in certain circumstances, may not have a choice as to whether to file bankruptcy in the face of a foreclosure proceeding. I hope these three situations were helpful to think through in the context of the loan documents, and now I'll flip to questions we've been receiving throughout this webcast to direct the panelists. First, I have a question here for David, who discussed, he was the first presenter. What standing do non-foreclosing junior and unsecured creditors have to participate in foreclosure proceedings and U.C.C. sales? And what roles do they typically play? David?
Sure. It really depends. Certainly, if a non-foreclosing junior unsecured lender doesn't have notice of the foreclosure, their lien often survives in the foreclosure. So it behooves a senior lender to name all the junior creditors in the case. But it really depends how much the senior lender wants to complete the foreclosure or wants to obtain title to the property, how much they care what the junior lender says, because in and of itself, the junior lender is entitled to credit bid if it itself establishes its right to foreclosure within the foreclosure, but it certainly can't credit bid without first paying the senior lender down in cash to eliminate its position. In terms of unsecured creditors, very little role in a regular foreclosure proceeding, because the foreclosure proceeding is generally the senior lender or junior lenders exercising their rights. Unless the unsecured creditor really wants to somehow take over the property and wants to bid, they really don't play much of a role. And in terms of U.C.C. sales, also generally very little based on that.
Thank you. Next question was actually directed to me, which is, to what extent does a foreclosing creditor have additional recourse under a bad boy guarantee once it takes title to a property through foreclosure? And that will depend on the triggers. So as I mentioned, the loan documents will have specific triggers for what happens in that situation. Here, the assumption is that it would be triggered once it takes title to a property, and I'm assuming that's because the debtor or the borrower did something to trigger it, either opposing the foreclosure sale or raising defenses or counterclaims or something of that nature. And if that's the case, the loan document would generally govern, and that recourse would be triggered. One other question here. If the debtor is a special purpose entity without material creditors, how big is the independent director's fiduciary duty? And if equity is pledged, does that help too? So this is directed to the last topic I was discussing, which is that of a blocking director and the corporate authority to file. And it's a very good question, because the structure of a SPE is generally to have it be quite isolated and have it not be subject to other creditors. The reason there being that helps protect it from an involuntary bankruptcy filing. So the question here is, well, who others' interests ought one to look at if you are a director of such an SPE and there aren't materially other creditors, and in this case, the equity has been pledged as well? Great question. I think that goes a long way, and I think the point of the Chicago case I mentioned is that the operating agreement specifically disclaimed that fiduciary duty. If it had preserved it, there was not a challenge to the bank's refusal to consent. Rather, it was the fact that they were not permitted to consider other interests. Well, good. That wraps us up for our panel. Thanks so much for participating and with the active questions. And we'll turn it back over to Amy with ABI for some wrap-up details.
Thank you so much, James, and thanks to all of you, James, Mark, and David, for really sharing your expertise with us today. It was a great program, and I bet all of our listeners learned something about foreclosures. Thank you. Just a reminder, for those of you on the line who have purchased CLE, you'll receive a follow-up email from us with instructions on how to obtain your credit. Thanks to everyone who attended. If you're not an ABI member and you're interested in learning more about ABI or ABI's Real Estate Committee, please email membership@abi.org. You can also visit our website at abi.org to learn more about ABI and our upcoming programs, including our annual meeting in Washington, D.C., April 20th through the 23rd. Thanks to everyone, and have a great day.